Sir, we are live now. You may please go ahead.
Thank you, Vikas. Very good evening, ladies and gentlemen. I welcome you on behalf of ASSOCHAM National Council for Competition Law. We are joined by the panelists of this virtual interactive session on the Competition Amendment Bill 2022, the key takeaways. Ladies and gentlemen, as we know that the Competition Act 2002 was enacted in year 2002 to provide for establishment of a commission to prevent practices having adverse effect on competition, to promote and sustain competition in market, to protect the interests of consumers, and to ensure freedom of trade carried on by other participants in India, and for matters connected therewith or incidental thereto. Recently, on 5th of August, we are aware that Competition Amendment Act 2022 has come in place, that has been presented in Parliament. And there were several amendments brought in the Section 3, Section 4, Section 6, a new section inserted in 6A, and then amendments in Section 8, 9, 12, 16, 18 that has been substituted, duties and function of the Commission, and the amendments in Sections 21A, 22, 26, 27, 31, 45, 46, not many changes. So it looks like there is a immense change in the Competition Act 2022, which is proposed. We understand that each and every amended clause will have some or other ways, some or other impact on the how businesses work and how they will impact, how businesses have to now comply in the new effect of this amendment environment. And there's a massive change. So due to that particular reason, and to apprise that what changes are meant to the corporate participants and stakeholders, we have scheduled this small roundtable session, which is virtual. We have been joined by the council, national chair of this council, Mr. Manas Kumar Chaudhary. He is the partner and head of competition law policy group, Khetan and Company LLP. We have been joined by Mr. Karan Singh Chandiok. He is the council co-chairman at ASSOCHAM and partner with Chandiok and Mahajan Advocates and Solicitors. And the panelists to address on the subject is also joined Ms. Diksha Manchanda. She is partner with Chandiok and Mahajan Advocates and Solicitors. And we have been joined by a number of participants joining still from the industry, corporate, academia, and we look forward to such a session which will be aiming at to address the questions as well on this particular subject. And I hope that the chair, co-chair, and panelists will address on important aspects of this particular, these all amendments which have been presented in Parliament. So before I invite for opening remarks to my council chairman, I would request and hand over the mic to Mr. Karan Singh Chandiok, council co-chair, who will be moderating this session and then taking this session forward. So over to you, Mr. Karan Singh Chandiok.
Thank you, Santosh, and a very warm welcome to everyone to this discussion on the key takeaways from the Competition Amendment Bill. As some of you may know, the Competition Amendment Bill came about as a consequence of the Competition Law Review Committee, which was under the chairmanship of Mr. Injenti Srinivas, who was then the Secretary of the Ministry of Corporate Affairs. The report was submitted in 2019. Subsequently, the Ministry of Corporate Affairs in February of 2020 opened up a draft of the 2020 Competition Amendment Bill for stakeholder comments. And as ASSOCHAM, as the National Council for Competition Law, we provided the Ministry with extensive comments from all our stakeholders on our views on what the good, bad, and the ugly as far as the Competition Amendment Bill of 2020 was concerned. After that, because of COVID and other reasons, the bill was delayed, and it went. And we hope that all of our stakeholder comments was taken very seriously by the government, and therefore it took time for a revised version to come out, which we've now seen in August of 2022, which we are discussing here today. The amendment was, while tabled, the Parliament was adjourned before its time in the monsoon session, and we hope that this bill will now be taken up in the winter session of Parliament. But the bill brings about some extensive changes to way Competition Act and antitrust enforcement takes place in India, as well as on regulation of mergers and acquisitions. It also brings about important structural changes to the CCI. Some structural changes which were mooted by the Competition Law Review Committee, or the CLRC, have been dropped, while some have been.
You've gone on mute.
You are muted.
Karan sir, you are muted or like that.
No, I'm.
Now I can hear. Now we can hear your voice.
Okay, I'm sorry. There must have been some technical error. I don't know what you last heard or heard anything at all.
So the difference between the suggestions made to the structure by committee and the bill.
Okay, great. Thank you, sir. Thank you. I needed that cue. Thank you. Without sort of repeating myself anymore and taking precious time away, the purpose of this session is to take you through these important changes and the key takeaways. And we welcome any comments and suggestions that you may have to make this regime even far more robust. And equally, any questions that you may have on what the implications of the bill are, we'll be happy to take them. Now, with that, it's with my pleasure. I want Santosh has already done a good job of introducing both Manas and Diksha, but let me warmly welcome them to this panel, as well as I'm going to post my first question to Mr. Chaudhary and ask. So you've been there since in part of the competition law regime from its very inception. And there was a certain purpose and thought behind the way the Competition Commission of India was designed as an adjudicator, regulator, as well as an advocate of competition law in India. It has multiple roles that it functions under. One of the key points was how do you divide between the prosecutor and the adjudicator, and with that, there are some changes which are thought through as far as this amendment bill is concerned. I'd love to have your thoughts on how the structure of the CCI is about to change and what implications it may have.
Thank you, Karan. Thank you, Santosh and his team, and also welcome to the session. And I would be also happy to be joined by Diksha, the young and the budding partner in the Chandok and Mahajan, who also has been practicing this law for quite a number of years now. So before going further, I would just like to answer to Karan's very, very pertinent and very important question. We all know very briefly that this Competition Act came into being on 13th of January 2003. Immediately thereafter, a couple of writs were filed, one before the Madras High Court in August of 2003, and later in October 2003 before the Supreme Court of India. The primary challenge of the petitioners was that since the MRTP Commission, which is the predecessor organization, had all along been headed by a judicial member, why would the commission, which is likely to take place and replace the MRTP Commission, not be headed by a judicial member? So the structure of the Competition Act was under challenge in 2003 itself, though the commission was notified on 14th October 2003. However, because of the intervention by the Supreme Court, most properly known as Brahmdev versus Union of India, the commission could not take any activity relating to enforcement or merger control until the Supreme Court disposed of the matter on 20th January 2005. Subsequent to that, there was a comprehensive amendment of the Competition Act, which came into being on 25th of September 2007. And post that amendment, the entire structure of the Competition Act in the principal legislation undergone a sea change. The major change in 2007 amendment was introduction of a competition appellate tribunal above the CCI, below the Supreme Court, and which of course was not there in the principal legislation. The combination regulation until that time was a voluntary regime that was converted into a compulsory regime. And besides that, the number of members of the CCI, including the chairperson, was reduced from 11 to 7. The commission came into being on 20th May 2009 for enforcement and on 1st June 2011 for merger control. So that's the structure at that point in time, that the structure was initially found to be fine, but because of the petitioners not being satisfied with not a judicial oversight before the matter reaches in final appeal to the Supreme Court, the Parliament thought that there should have been a necessity of an appellate tribunal in between, and that was a structural change introduced in 2007 amendment. With regard to the current amendment, it has also to be seen in the light of some changes which has already been made in May of 2017, when the appellate tribunal, which we used to call as compact, got merged into NCLAT, which is the National Company Law Appellate Tribunal. That merger happened on 26th of May 2017, which is a very, very interesting structural change. Perhaps the government wanted to have some clarity, reduction in cost of running the authorities, and maybe expeditious disposal of the appeals from the CCI orders. The current amendment bill tries to even further make a structural change, which is very, very interesting to address to the audience. The Office of the Director General, which is the investigative arm of the Commission, is proposed to be merged with the Commission. Now, if I go back to the Brahmda judgment of 2005 and subsequently the CCI versus Sale judgment of September 2010, the Supreme Court repeatedly held that the CCI, under the Competition Act, has the following statutory powers: adjudicatory, regulatory, inquisitorial, and advisory. So with the change in structure as proposed in this particular amendment bill, that is DG getting merged into the CCI, this ratio of the Supreme Court repeatedly held that it has got 3-4 different roles, which would also subsequently get merged into an adjudicator, inquisitorial role, and the investigation, all to come under one particular authority. I stop here. I would be happy to have questions, and if Karan and Diksha may also like to add something, please go ahead. Thank you.
So, in terms of the practical impact of the merging of the DG office, sort of from a prior position of being almost a separate statutory body or being very arm's length from the CCI to a body where the appointment is now going to take place from the from the CCI. So do you see any, in terms of the number of the cases that you handle and investigations that you are part of, do you see any changes with the way in which the current manner in which the DG is functioning and the way it will function going forward?
So that's, a very interesting corollary to what I have just shared with all of you. First of all, if I have read the bill correctly, the powers of the DG, besides get subsumed into the CCI, also gets enhanced considerably. If I look into the powers of the DG, first of all, the DG would be now an authority who can independently move without the recourse to Section 240A, that is the 1956 Companies Act, whose latest corresponding section is 220 of Companies Act 2013. It does not require to get the CMM New Delhi to issue a warrant of search and seizure. The DG itself can move an application. DG here thereafter would mean CCI, can move an application before the CMM New Delhi, requesting it to cause a dawn raid, that is search and seizure operation, at the premises of any company who is under investigation. Now, interesting feature, Karan, is that the law defines agent under the powers of the DG, and an agent of a party. Party has been very, very broadly defined under the definition clause of the Companies Amendment Bill. The DG's powers say an agent can also be investigated. An agent, they say, it includes, it is beyond the party. And how does that agent has been explained under the bill? It includes chartered accountant, bankers, and legal advisors. Now, the definition of legal advisor, I believe, is equivalent to an external lawyer, because an in-house counsel would continue to remain not an external legal advisor, but would be an employee of the enterprise. So naturally here the legal advisor, to my mind, indicates that an external lawyer can also be directed to depose on oath before the DG and it extends to even causing downgrade at the premise of a legal advisor, which can expose a law firm for even getting the incriminating documents if at all there is a communication exchanged between the lawyer and the client, which otherwise is protected age-old 1872 Evidence Act, Section 126. So all of these are likely to be compromised if at all these powers are being exercised the way it has been drafted. So I think it's a very serious departure. And I do not know whether any other authority has this kind of power in a civil legislation that they can really go out and direct a lawyer, external lawyer who is governed by Advocates Act, the disciplinary proceedings of the Advocates Act, governed by Section 126 Evidence Act, can be directed to depose and disclose all privileged communication which it may have with the clients, and then the company to which the lawyer represents, either his own firm or a law firm as big as any top law firm in India is concerned, is exposed to some kind of a downgrade and a search and seizure operation. That's something which we need to deliberate. And I think that's something very, very serious. And we have to really understand what the intent of this new addition of agent definition in the DG's power is concerned.
Thank you, sir. I'm going to now switch to Diksha for a question on structure before we go into sort of the depths of the substantive changes in the law. Diksha, as Mr. Chaudhary has been saying, there has been now an increase in the power as far as the DG office is concerned. There's also been an increase as far as perhaps the CCI's powers are concerned. The one way to have judicial oversight over the CCI's power was the creation of the then Competition Appellate Tribunal, which is now the National Company Law Appellate Tribunal. But also, despite that, the Delhi High Court has felt that there is a requirement when the CCI is undertaking judicial functions and judicatory functions, that there should be a judicial member. However, despite that, although the MCA had previously come out with an appointment for a judicial member, since then there has been no such appointment or even notice to call for applications for such appointment. Where does the bill stand as far as that is concerned, and where do you see the future of the fact that whether or not we will have a judicial member or not?
Thanks, Karan. I think it's important to make the primary position very clear here, which is that under the current law as set out by the Delhi High Court, which itself draws from very well-established decisions of the Supreme Court, it is necessary for a judicial member to be present for adjudicatory functions. There, of course, has been an attempt by the MCA to appoint such a judicial member, but we know that currently that appointment has not been made. Unfortunately, this bill misses out an opportunity to get more clarity on this point. This bill could have been used to actually make an amendment to Section 8 of the Act, requiring the presence of a judicial member and providing a statutory respect to what the Delhi High Court said, but that has not been done, unfortunately. So we'll still be waiting for the government actually to take that move of appointment, but it doesn't get any statutory recognition. So I feel that's one place perhaps where when it comes up before the parliament, we may see a change, and hopefully there'll be a statutory recognition given to the fact that a judicial member needs to be present within the commission.
Thank you. Okay, I'm going to now, because being conscious of time, I'm going to move on to some of the more substantive changes in the statute itself. We had changes as far as cartels were concerned. There was been the CLRC suggested that there should be, and we also saw that in the previous iteration of the bill, the inclusion of buyers cartel, hub and spoke. Some of these have remained and some of them have been taken away. And this is open to both panelists if you want to take either of those to explain how those changes in as far as cartel conduct is concerned. We also have a new leniency plus regime, which has been introduced for faster detection of cartels. And the leniency regime in India has been a bit of a slow starter at the beginning, but since then picked up for lost time. And there have been a number of leniency applications that have been made, and the CCI has come out with various decisions laying out what it believes is which candidates can go ahead and actually take benefit of the leniency regime. Now, the leniency plus regime takes to expand that. So if either Diksha or Chaudhary, if you'd like to take that forward, I'm sure the participants would like to know more.
So Karan, I'll just partially take a bit of it and then I'll hand it over to Diksha. First of all, there are some very positive takeaways. One is that the buyer's cartel, which I think had been one of the areas which remained kind of a gray area in the Competition Act. So that has been added. The second is that in Section 3, subclause 4, that is what we call popularly vertical agreements. So in vertical agreements, there was a very minor changes required, which has been added. They always try to say in the law, the goods and products and provision of services was missing. So that has been added because that makes the completion of the implementation of vertical agreements. We thought that in Section 4, the intellectual property rights would be finding a place besides the anti-competitive agreements under Section 3, subclause 5, but they have not inserted IPR in Section 4, which we thought it would have been added, but not added. Very interesting positive changes have been made in two new features of the antitrust proceedings. One is commitment and one is settlement. Now, in case of these two, what are these terms are? They have inserted in, I think, 48 capital A and 48 capital B of the bill. In one, it says that after the formation of the prima facie order by the CCI, except in the cases of cartel, only in case of vertical agreements and abuse of dominance, once the CCI has formed the prima facie view, directed the DG to cause investigation, any party who is able to access the 26(1) order, that is the order of the prima facie, which normally is always available on the website of the CCI, unlike the cartel prima facie orders. So they can reach to the CCI and request by making an application, which of course will be prescribed as per the regulations which would come out after the bill becomes act, that they would like to make certain settlement with the commission, and the DG's investigation can be halted by an order of the CCI, and the party who is seeking this commitment also would be subjected to a couple of things. One, there would be an order where the CCI would also be at liberty to impose some kind of a penalty, because the moment a party makes a commitment, it means it's actually admitting the breach. And at the same time, any order passed by the commission of this commitment is not appealable. So it actually makes it almost like an out of settlement, which in civil law is of course not appealable. And they have also made that it is not appealable, which actually settles the litigation at that level. In the case of settlement, it is when the DG has commenced the investigation and the party has gone before the DG, and during the continuance of the investigation found that it may be landing up into some kind of a problem, and it makes an application to the CCI that kindly allow me to settle the issue. And if CCI finds before the closure of the DG's investigation report that yes, the settlement may be allowed, again, the same principle would follow. Based on the merit of the application, CCI may like to impose some kind of a penalty, and thereafter it can direct the party to pay such things, and then there is no appeal. Interestingly, Karan, all words, wherever the word appears fine, they have all been replaced by penalty, which is a very, very positive change, because fine has got a criminal connotation, whereas penalty is a civil liability. So that actually settles one of the basic contentions which we always were grappling with. The Companies Act 2013, Schedule 5, says that if any director is imposed a fine of 1,000 rupees plus by any authority, including the CCI, then he loses his directorship in the board. So with the word having changed from fine to penalty, that provision has been taken care of very, very diligently, and we all should appreciate that. I stop here I would now like Diksha to take other areas.
So much, sir. So I think, as sir was saying, there have been some very beneficial and progressive changes in the area of cartels. And one of the main ones has been in the way the leniency regime has been structured till now. And we see two very positive amendments sought to be made. The first one is permitting a leniency applicant to withdraw his leniency application. And this is going to benefit companies, especially where, in a race to file a leniency, you've not examined all your defenses very appropriately, which has gone to the commission and put in those papers. If it is felt appropriate at a later stage, then that leniency application can always be withdrawn by you. And the second is introducing the regime of leniency plus, which have been seen in other jurisdictions. And at some point of time, other authorities have felt that it has been very beneficial. What is this leniency plus? It basically allows a party who's being investigated for a cartel to come and make a disclosure about any other cartel. And then the benefit of a leniency in the second cartel can also be extended in the first cartel. So I essentially make one disclosure, but with that one disclosure, I stand to get two benefits. And that is something which is likely to increase the possibility of parties coming forward and making these disclosures. That said, of course, globally, there has been a little bit of a downturn in leniency applications being filed. So with this amendment, perhaps in India, we can keep the level of leniency applications filed constant. And that seems to have been the aim of the commission and the ministry in pushing forward these amendments. And finally, so it spoke about the buyer cartel. The other important thing that has been done is to clarify that cartels are not now limited to competing parties. If you are actively participating in a cartel, but you're not competing with the other participants, you will still be liable. This is primarily, we understand, targeted for hub and spoke kind of cartels, where you may have a manufacturer transmitting information to retailers, for instance. And this is a slightly more complicated and complex area. It will need a little nuanced application by the commission, because currently the manner in which a manufacturer and a retailer interact on prices, it's covered as a vertical agreement, vertical violation, which means that there is a requirement to show that competition was impacted. If this is shifted to a cartel status, the burden on the commission reduces, which means companies now need to be a lot more careful in how they are engaging with their distributors, especially on price-related issues. And they will need to ensure that there's no leakage of information from the company vis-a-vis the distributors, because it can make them liable for a cartel which has a lower evidentiary standard and burden than a vertical agreement does.
Karan, I would like to add a few more points which came to my mind while Diksha was making submissions. One is that, we have always been asked by international community, the competition fraternity, whether you have a limitation period. So the commission the bill has added a 3 years limitation period insofar as matters relating to filing of information under Section 19 is concerned. The period is 3 years, which of course can be extended by showing sufficient cause, and the commission will take a call on the basis of merit of those sufficiency and may grant additional time. But then the law is very clear. They have added a 3 years period of limitation for filing information before the CCI. The second interesting change which I would like to share with all of you is that the orders which were typically called closure orders, the CCI formed a prima facie view directing DG to investigate. DG concludes the investigation, confirming the breach, but in the final hearing, CCI closes the matter disagreeing with the DG. In such final orders, until now, there is no provision of appeal available under the Competition Act. That has been introduced. So that is under Section 26(9), which has been added and also properly included under 53 capital A to make it available with the NCLAT for appeal. The other very interesting change is until now, whenever there is an appeal filed before NCLAT with a penalty imposed by the CCI against the appellants, we have typically found a procedure was adopted in the appeal so far that payment of 10% of the penalty could be made by way of fixed deposit receipts in favor of the registrar of the NCLAT, and then you get the appeal instituted for listening on merit. This has now been made a part of the law, but a little stricter, that a party who would be preferring an appeal against a penal order where it has been handed out with a penalty, the 25% of the total penalty amount imposed by the CCI will have to be deposited to the registrar of the NCLAT before the appeal can be instituted for hearing on merit. So this is a very interesting departure from the practice which has been going on for so many years. And the third and very interesting, that in case of a compensation application, until now it is as soon as the CCI passes the order, the parties are at liberty to file simultaneously a compensation application when perhaps the appeal is also going on by a party aggrieved. So they have made it very clear that whenever the Supreme Court order comes out, the parties may have a right to file compensation application, which clearly means that after the order has attained a finality, insofar as the highest appellate authority is concerned, only then the compensation application becomes fileable before the NCLAT. However, if a party does not prefer an appeal, then immediately a person can file a compensation application. These are some of the very interesting changes.
And so how do you see that working out, especially when considering, when we look at law of limitation, if there is an appeal is not filed in time, does not, while a favorable right accrues in favor of the other side, it may not always be the case. There could be reasons why someone may be delayed in filing their appeal. So aren't we now looking at more applications asking for and belated appeals being filed to thwart any legitimate legitimate applications for compensation?
That could be a definitely downside to this positive change. And as we know, Karan, in civil litigation, this is more often than not, the most of the applications are Section 5 of the Limitation Act, that please pardon me because of these sufficient reasons. And all of those ratios are available up to Supreme Court, and anyone being aggrieved by this limitation period can always go and make a request before the CCI seeking similar reliefs. That is possible, no doubt about that. But definitely, it would minimize that uncertainty. That if you suppose historically, because in Competition Act, it is an economic legislation.
Yes.
If suppose I have some kind of an agreement of coordination in price or limiting production in 2009, and all of a sudden some party feel aggrieved because maybe political or economic rivalry, files an application before CCI in 2022. In the absence of a limitation law, the CCI is mandated to institute it. It may close it at 26-2, but then the entire rigmarole of filing, then the entire secretariat of CCI getting into placing it before CCI, everything, it's absolutely a cost to the commission. So that would definitely minimize to quite a great extent.
So I want to come back to what you mentioned about settlements and commitments and how that is perhaps going to practically work out. And I'll keep some time at the end for that. Diksha, I'm going to ask you a question on, there are lots of changes as far as combinations is concerned. When we look at our law, we have practically 4 sections that we deal with, which is section 3, 4, 5, and 6. They lay down the substantive laws that we deal with. From our perspective, from your perspective of those changes which have come in as far as combinations are concerned, both in terms of thresholds as well as timelines that have changed, how do you see that practically working out? Because that is something which stakeholders are always concerned. Is there any additional regulatory burden as far as them closing transactions is concerned?
So as Karan, you rightly said, there are 2 parts to it. There are a lot of changes in combinations, but I think the 2 which actually would lead to change in the way things have been working are 2. Number one is the thresholds, new thresholds being defined, and second is the slightly reduced timelines. So I'll deal with the slightly reduced timelines first. We've seen that they want to bring down the change from 210 to 150 days. So the total period available to the commission for review of a transaction has been brought down to 150 days. Consequently, a lot of steps in between the timings for those also have been reduced. And while this is good news, I think we should be cautiously optimistic about it, because this timeline is subject to us providing any information as parties that the commission may ask for. And the time taken by a party to supply any additional information is excluded from this total time limit. So we may see situations where effectively the time that is taken by the commission to approve a transaction doesn't really change much. It remains in the neighborhood of what we are currently seeing. But on the threshold side, I think that's where parties may feel increased burden, especially because right now it is not very clear whether this is going to be limited. The new thresholds are going to be so they apply everywhere. Just for the attendees who may or not all be completely aware of what has happened, we earlier had an asset and turnover based threshold. So if the companies who are merging or amalgamating cross a certain value of assets and turnover, it would be notifiable. The commission has now introduced a new threshold, which is the deal value.
Diksha, I'm going to interrupt you. I think we lost you in the middle, so very low voice. If you could repeat the last 30 seconds. It's a little louder.
Is it better now? Okay, great. So earlier we only had two thresholds for notification, which was the assets and turnover of the parties who are merging or amalgamating or acquiring, the target and the acquirer. Now we have a new threshold as well, which is the value or the deal value, basically the consideration that is taken by one party from the other for the transaction. And this new deal value threshold, we understand, has been included to bring within the scope of the commission's review certain transactions which were not getting reviewed because the asset and turnover value might be lower. The understanding was that this is limited to the digital sector, because digital markets are where mostly you see assets and turnover not being very large, but the company is playing a very important role in the market. Unfortunately, the Act, or maybe fortunately, the Act is not very clear on whether this is limited in terms of the sectoral scope. So we'll have to see if the Commission actually limits it in terms of the sectoral scope. If not, then yes, we might be looking at a lot more notification filings being done across sectors, especially sectors which see generally high value transactions. They could see a lot more notifications. The good thing is that the Commission has noted that we would need any transaction to be notified would need to have a substantial nexus to India, business connection to India. We don't know how they're going to define it. Recently, the chairperson in an interview said that they would be looking at matrix, like what is the user base of the acquiring and the target parties. This is all, the jury's still out on this, how it actually impacts, but definitely there will be an increase in the obligations of the parties to seek approval from the Commission.
So Diksha, so it seems quite laudable that they've reduced the timelines as far as merger control review timelines are concerned and brought them down from the previous. We had 30 working days, it's now 20 calendar days. 150 days outer limit has been set as well. Do you think, are we going to look at far more time spent by parties in going to the CCI and going to the merger control division and saying, here is my draft filing, please look at it, and therefore only then do a filing? Or you'll see a risk of parties going into the CCI is not getting enough time to review the transaction and then invalidating the notice because they've not had sufficient time.
So yeah, as I said, I think practically how these reduced timelines play out, we'll have to see. There is a possibility of you getting more notices from the Commission to reply, which stops the clock. and there is a possibility of invalidation, as you rightly pointed out. If the commission needs more time, both of these are likely to be used. And I think resultantly, it will always be smarter for companies to move to the commission first with a form in a pre-filing consultation to ensure that whatever goes into the commission fulfills every requirement. And that, of course, is mutually beneficial. It's beneficial for the commission because they get a slightly, preview of what the transaction is like, and for the parties because it makes it easier for the timelines to be, understood at the outset. But there are a lot of other positive changes as well. For instance, for market acquisitions, the commission is now going to hold back its hand in terms of gun jumping and come out with detailed guidelines of situations where open market acquisitions can be done without attracting the gun jumping requirement. So I think overall on the merger front, it's been positive. Even for DVT, it's positive because they've at least recognized that there has to be a nexus with India. So not every transaction is going to get covered. The devil will lie in the details of how these regulations come out and how they actually impact. And some part of it will depend upon the practice of how open the commission is to working collaboratively with parties. Till now, it has been very collaborative, and we hope that it continues the same way.
Mr. Chatri, I'm going to ask.
Karan, if I add a couple of things.
Please do.
Yeah, thank you. One is that the 26%, which was in public interest under Section 54, enhanced to 50%, and that has not been reviewed and renewed after it expired in 2022. We thought that in the bill, perhaps that 26 would be 50 because that is international practice insofar as merger control under competition regime is concerned. So that may continue to remain a concern for the parties who are coming before CCI for filing. The second issue is that, there are some changes in the definition and control. They have added in the law itself that material influence would be considered as a control. And we all know that material influence is little lower threshold than decisive influence. So that could be another area where parties will have to be very careful about. And with regard to that 150 days, I personally feel that there is a provision already incorporated in that law itself that on case-to-case basis, if there is an unavoidable circumstances, the commission may be approached for enhancement of these 150 days. And commission in all probability, seeing the merits on case-to-case basis, may even go beyond 150 days. So they have provided an enabling inherent provision in extending the period of 150 days. But Karan, as we all know, that currently under Section 29 and 30, we have got those enhanced powers of the commission when stipulated, say 45 working days has been provided for, say, public consultation, and then thereafter responses of the parties required. If they fail to gather the correct information, the commission in all probability would be able to grant additional time, because end of the day in a merger control, it is actually a pro-competitive activity of the business houses, where one of the companies may be willing to exit the market and the other is wanting to revive that situation. So in all probability, the commission's intention as of now has been exceedingly good. And we all know that 98% of the combinations under 31(1) that is approved without any condition is the record of the CCI. And whatever little had been modified, that is very low in percentage. And until now, the commission has not blocked any transaction, which is very common across jurisdictions. So combination regime insofar as CCI is concerned has been extremely positive. And with these changes, I think the things would enhance and would improve rather than concern. So that is one area I thought I should share. And the second is the amount of penalty under Chapter 6, that is the non-compliance part, both in Section 44, that is whenever there is some kind of a suppression of material fact or there is a non-compliance on the part of the order of the CCI by the parties, the penalty until now is 1 crore, which has been proposed to be enhanced to 5 crores. So these are some of the areas which I think the parties need to also take cognizance of, that the penal consequences have been proposed to have been added far more than what it is expected.
let me ask then a question which ties in with what you said. Now, if you have this change, which was sort of moving from the CCI's decisional practice on leading towards more into material influence, now which is statutory recognized. We also at the same time have this group definition, which pegs it at 26% and above, which sort of don't seem to sit well together because if you look at material influence and the decisional practice, they always say, but at least even if you have nothing, if you don't have, you can block a special resolution at 25%, at least in India and Indian companies you can. So you would have deemed to have material influence. So why then include a definition which says 26% and above? Where is that 1% missing? It's always baffled me, and I thought I'll ask you this question at some time, but why not at this public forum?
I think we have to wait and see as the evolution of this jurisprudence evolve. But when this notification was coming to an end, we actually had approached the CCI as well as MCA, requesting them to make it 26 to 50% and renew the exemption. But unfortunately, it did not see the light of the day. So what I could conclude from those days to this bill, that there is definitely a policy level decision at the government not to really enhance this to 50%. And that is where, I think we have to inform all our members in the ASSOCHAM as well as our friends overseas whenever they are trying to make some filing before the CCI about this and how this has to be properly understood, ensuring that the expeditious disposal is not hampered because of these issues. And one more point, Karan, we have been harping for penalty guidelines, which has been added in the Act itself. So there is no doubt about it to come via an regulation. It is now part of the substantive law. So that's something very interesting, that predictability as to how a penalty can be imposed by the CCI in antitrust cases. That is also something very interesting to share with all the audience.
A common response to that, sir, is that when we see penalties, it will allow for parties to game and see how much if they know what penalties they will face. They will be able to game the system and see, okay, I'll just add it as my transaction cost. I will just add it as my cost of doing business. How do you see that versus how do you balance that with the certainty required by stakeholders as to what penalty they could be facing?
Karan, if you ask me, my personal view is any enactment should be less of definitions and explanations. The law must evolve on its own because the market, insofar as the competition law is concerned, is extremely dynamic. If we go back to the grandfather of the antitrust law, that is the US, in 1890, they have had n number of amendments made from 1890 until today. So how they are making the amendments, their original legislation continues to remain the same. So the amendments is a thing which is to stay in a competition regime, but making it so explicitly defined actually makes the role of the authority also very difficult because you have defined. Now there is nothing really to say that let the law evolve because you have already made it available in public domain. It is almost turning out to be a sector regulator, that I have got the regulations already available on the website. You have to follow that regulations, as simple as that. On the contrary, Competition Commission is not a regulator. It is actually an authority which is trying to rectify the market distortion. So market distortion is so unpredictable. Say, for example, between traditional companies and the digital company, you really cannot put the traditional company issues into a digital company and still say that I am trying to implement the law correctly. So in such circumstances, it is always better to have a law evolved rather than define, explain every bit of it as if you are becoming an advanced regulator, advanced adjudicator. That I think, as you rightly pointed out, parties may game the whole concept of too much of definition and explanation in the law.
So because we have only a few minutes left, Diksha, the important point which Mr. Chaudhary had previously touched upon was settlements and commitments. It ties in with the penalties that we were just talking about. How do you see that regime, and So first, if you don't mind sort of giving an overview of what we can expect practically, and what would you like to sort of make the regime even better than what it's already legislated or proposed to be legislated?
I think the proposal is a very sound one. It brings in a lot of efficiency in how matters are decided, and I think it's very positive change, very positive move by the government, of course, initiated by the CLRC. So all thanks to the Commission and the CLRC for this. But in terms of how it will play out, the way it's currently designed, settlements and commitments are both limited only to cases where vertical agreements or abuse of dominance is being looked into. So we don't have any settlement or commitment regime for cartels, which fall within the scope of leniency, so perhaps not a big loss there. Settlements can be brought about after the DG report has been put in before the Commission. Commitments will be before that stage. In both cases, as Manas was saying, appeal is not going to be available. But all parties will have an opportunity to make submissions about these settlement and commitments to the Commission. So as an opposite party or an investigated party, I can make an application. And if there is an informant in that case, that informant is going to be given a chance to actually come and speak to the Commission on whether they think the settlement and commitment proposition and proposal is good enough. What can be done to make it better and how it will play out? I think here again, the devil is going to be in the details. The proposed act says that the CCI will have to come up with regulations on how both of these are going to play out in reality. One very important thing to see is what is the level of prejudice that I carry with me as an investigated party when I make that proposal or settlement or commitment. Assuming I have a negative DG report in case of a settlement, if I go to the Commission, will I be deemed to have admitted my wrongdoing? Because if that happens, I think the attractiveness of both settlement and commitments for the parties is going to really fall down. The whole idea behind these mechanisms internationally is to try and come to a very expeditious resolution and to try and get the market to a place where the regulator thinks it should be. It is not necessarily pinning down wrongdoing. And if you do pin down that wrongdoing in India, if it is as an admission of my guilt, that has follow-on consequences for these companies because people can file compensation claims against them. There's no protection currently under the Act for those compensation claims. So to make it better, I think it will be very important. It's a miss that the Act did not specify that these would be without prejudice, but it's very important that the CCI regulations prescribe that this is without prejudice, so that companies can come forward and do it with a little more open heart. I think the other place where I think there has been a miss is ability of a complainant to withdraw the complaint and the impact that has on ongoing investigation. I think with settlement and commitments, perhaps the Commission could have introduced a provision, allow an informant to withdraw the information and then set out a method of how to impact the investigation. Conscious that these proceedings are in rem, they are not in persona, but there are times when the issues are really inter partes. So there should be power or discretion given to the Commission in those situations to truncate the investigation. Again, all in the interest of saving resources. So I think that is a miss. If that can be included in some way within the settlement and commitment regime, it will be very beneficial. One of the factors, for instance, on why I would accept a commitment would be because the informant has withdrawn the complaint already. So I think these are some things that can be done to make the regulations a little more robust and to ensure that everybody can get maximum benefit out of the settlement and commitment regime. The Commission as well as the investigated parties.
Thank you, Disha. I think we have a number of questions from some of the participants, and I'm going to take one of them. I think you've answered one already with regards to follow-on damages. There is one from, and that question was Mr. M.M. Sharma. I'll just read out the next one, and this is to Mr. Chaudhary. How do you respond to the contradiction in the bill regarding including the term buyer in the definition of enterprise under Section 2C vis-a-vis insertion of department of the government in the definition of consumer under Section 2F, considering that government departments are major buyers too, and CCI has lodged a number of cases against PSU buyers despite evidence of limiting market for supply by imposing selective condition. Is it not a retrograde step which will further encourage anti-competitive behavior by PSU buyers?
Now, if I look into the definition of 2H, accepting the sovereign functions and that too relatable to atomic energy, defense, space, and currency, all government departments, including the public sector undertakings, are part of the Competition Act even now and even post-amendment. Now, the question which my friend Mr. M. Sharma has raised is relating to an interpretation, because Section 2C defines cartel, and in the cartel, if they do not include the word buyer, then the main substantive change which is proposed to be made under Section 3 subclause 3 to include buyer's cartel, then there would be a disconnect. So in order to read it logically, holistically rather, and in consonance with the correct interpretation of statute, 2C, 3.3, 2H will all have to be read together, because the bottom line is the government departments and the private parties are equally within the ambit and scope of the Competition Act, and we have a complete competition neutrality under the Indian Competition Act. So we just cannot say just because one definition has made some kind of a contradiction with regard to another, we have to harmonize and find the best way forward, because as on today, we all are aware that the public sector undertakings are equally vulnerable under the Competition Act, and there are many cases. I don't need to give examples, but I think we have to harmonize these kinds of apparent contradiction, which I believe as the law evolves, it would really settle the issues quite properly, as we all know that it has so far been able to get the public sector undertakings. Say, for example, a few cases which have gone into the appellate tribunal against the PSUs have all been confirmed. So that clearly settles that the jurisprudence evolved thus far, insofar as the PSUs are concerned, are really not going to be benefited from this amendment. They are equally vulnerable and they will continue to remain vulnerable.
So I'm going to ask this question to both the participants. So if you had a choice, a free rein to make two changes to the current proposed competition bill, what would those changes be and why?
So Karan, if I go first, I would like the word legal advisor in the explanation call of agent be immediately dropped, because it would not only jeopardize the whole process of legal representation, because legal representation is a constitutional guarantee. A party who is not trained in law most of the time would face leading questions, and in such circumstances already the exclusion of external lawyers under Regulation 46 capital A has already caused a lot of damage to the investigation. And if we are now asking the lawyers to come and depose on oath on behalf of parties, I am sure many of the lawyers will refrain from representing parties via wakalatnama. And if that is the intent of this amendment, then it would be CCI versus industry. There would be no representation of lawyers at all. And that, I think, should be the immediate takeaway. In the definition of agent, the legal advisors must be omitted forthwith.
I think sir's wish list is number one. That is, it's an extremely important change. It's I think a big miss from copying provisions from the Companies Act. There has been a big slip, and if it's intentional, then it has massive consequences that sir pointed out. But if I were to take some other two picks, I think for settlement and commitment regime, the clarity of them being without prejudice would have been extremely helpful. And in my wish list is also to reintroduce the IPR exemption for abuse of dominance. That's discussed. The last bill, the draft bill had it. And it's extremely important for that provision to come back, because there are increasing number of cases where people are going against holders of IPR, where holders of IPRs may be filing suit or vis-a-vis their licensing practices. The Commission has adopted a very nuanced approach in all of these cases, more recently, even more so. But I still think an overarching exemption of the kind that Section 3.5 has, which is very well worded. It doesn't eat into the powers of the Commission, but doesn't take away from my right as an IPR holder. Something like that for abuse of dominance would be very welcome.
Thank you to both of you. I think if we have about 3 minutes to take any audience questions, if you have, please set them in the chat box. I've just received one. Would you agree that the provisions of proposed section 41.8 and 41.9 should be deleted since they give extraordinary judicial powers to DG and executive body to order imprisonment, which even CCI does not have? Chaudhary, would you like to address that?
Karan, all these issues is giving me a view which is not so good for the industry, which is that there will be a plethora of writs because both CCI and as of now DG, which are, of course, we know they are no longer there. There are other authorities under Article 12 of the Constitution, hence a writ lies. So if these provisions which are actually contradicting with each other and they're repealing by implications, if they stay in the bill and ultimately come by way of an amendment act, I'm quite sure that whosoever would be agreed by these decisions of the DG would prefer to move a writ. And in the process, perhaps CCI would be engaged in defending writs in various high courts across India, and which I think is not the intent of this amendment. Amendment is always should be a forward-looking kind of a thing, which should be able to plug in the loopholes during the evolution of the life cycle of the Commission. It has rather retarded to some extent with the enormous powers given to the DG, because the office of the DG virtually would become CCI. And in such circumstances, the powers that be, as Mr. Sharma has raised, is going to really be adjudicated only before a constitutional court. It cannot be remedied by CCI.
Thank you. There's one question is, when are these amendments going to be in effect? I think safe to say that this will only be after the Parliament has had a chance to review, consider, and then pass this legislation, and then it would go for the parliamentary process, the legislative process in India for the president, and upon his signature when the government decides to notify these changes. So perhaps at least not till this, towards the end of December, early January is perhaps the earliest we can expect this to take place. So with that, I want to thank both my panelists today for taking their time and giving us an overview about overview on the Competition Act. It's from our discussions today, there are more hits than there are misses, but there are some misses which can lead to a lot of heartburn as far as both practitioners as well as industries which face investigations by the CCI or are taking their mergers and acquisitions through the CCI for approval. But the CCI has largely been open for stakeholder comments, has been regularly using forums such as the ASSOCHAM National Council to receive feedback. And we look forward to receiving all of you who joined us today as attendees, your feedback on how the National Council can engage with the CCI and improve the enforcement of competition law in India. Thank you very much for joining us today. Santosh, over to you.
Thank you so much. Thank you so much, sir, for this moderation of the session. Thank you so much, Manas sir and Diksha ji, for making this enlightening session. And I hope that participants would have taken a lot of information. You addressed the questions very well, and hope that brings a lot of clarity to all the corporate stakeholders. Perhaps they are not raised the questions herein, but we hope that they would have received the good stuff of information on this particular subject of amendments in the Competition Act. With your permission, sir, I have a small announcement, as we have already got the confirmation from the Honorable Chairperson of Competition Commission of India, So we shall be having this conference of the year, that is in 7th International Conference on Competition Law. That's on 15th of October. So it's a small announcement. Members, participants who are attending this conference are mostly also the participants who would have attended our earlier conference last year we had in September 2021, wherein more than, since this was a virtual event last year, so we had almost 3,000 participants from almost 12 countries. And we look forward this year as well to make this conference of 2022 a big event, which would be bringing a lot of clarity, a lot of questions, answer discussions, with a lot of participation of the speakers from CCI, from other regulatory bodies, from the government, and as well as from the side of the corporates and from the national international fraternity of this legal community. So we look forward to continued participation. We shall keep apprising the details of the program, and we shall keep requesting for your inputs, what can be addressed. So if industry apprises and shares that what can be of their interest, we would be keen to also include in this conference, which is upcoming on 15th of October. So we will share across the all details in the due course, and we would just say thanks to all those who are attending over here and making this a small gathering, a small virtual session very successful, in terms that this is first, I think, to ASSOCHAM's council. After this competition amendment bill has been presented in Parliament, and that's where at a very short notice we could see good participation of the corporate participants over here. And thank you very much for making this a wonderful session, as always. With all the moderation and chairmanship of chair, co-chair, Manas Kumar, Chaudhary sir, and Karan sir, Diksha, always for your kind support. Thank you so much for making this very enlightening session. Thank you so much.
Pleasure.
Thanks,
Thank you.
Santosh. Thanks, Shantanu.
Well,
Thanks to
thanks.
everyone.
Thank you.
Thank you so much, sir.
Thank you. Bye-bye.